been invited joins, then I will, of course, admit them as we go on. Having said that, though, I have three applications before me. It is an application for leave to cross appeal, together with a condemnation application, and then an application in terms of Section 18, Sub 3 of the Superior Courts Act. I've gone through the papers, I've read the applications, I have also received the sets of heads of argument from the applicants, which are Mr. De Beer and the Liberty Fighters Network, and that of the respondent. The issue or issues are slightly emotive, and I noticed that also from the papers, but as we are here to deal with the applications on a legal basis, let's keep and restrict ourselves to legal argument and factual argument. Mr. De Beer, would it be more convenient for you to present your argument by way of your heads of argument and the structure therein? It starts with the condemnation application, the application for leave to appeal, that's the cross appeal, and then the Section 18.3 application.
My Lord, I have produced the heads of argument. I've only highlighted the new matters that basically arose from what we had in the last instance. So in that respect, there might be a couple of things that I just need to add to the heads of argument, if my Lord would allow me to do so.
Yes, certainly, but in that argument also there was the issue of urgency raised and still raised by the respondents. For purposes of practicality and convenience, I do not propose dealing with urgency separately because it is to an extent intertwined in the other applications and in the nature of a Section 18.3 application. So let's hear all the arguments jointly. So I'll hear you first, and then Mr. Trengove, and then you in reply. And then in dealing with your application, then also be mindful of the issue of urgency and the objection against it.
Yes, my Lord.
Yes, Mr. De Beer.
Thank you very much, my Lord. What I would like to address first is that we have lodged, obviously, the application incidental to the leave application as well. Would my Lord first like me to go into the condemnation application before we go on, or how?
Yes. Well, let's start with the application, the condemnation application. That is for the leave to cross appeal, because the leave to cross appeal is out of time, and it is way out of time. And in order for it to be entertained, there must be condemnation for the late filing thereof. And let's deal with that. Why is it so late?
My Lord, as I've indicated in the affidavit, we have highlighted several factors to that extent. We have also noted that we have not received an opposition, formal opposition to our condemnation application from the respondent side. We have, however, I did see that the respondent's legal team have addressed urgent or the condemnation application in the heads of argument, and I don't know whether that is actually suitable to present to oppose a matter through a heads of argument if there's not sufficient papers before the court to actually know what the issues of the respondent are before why.
No, Mr. De Beer, let me interrupt you. It is sufficient because the condemnation is not just for the asking, and the applicant in the condemnation application must set out good grounds, which can be attacked on its own papers as well. I don't think that a factual allegation is necessary. Let's just hear you. Why do you say the application for cross appeal should be heard so late after the applications for leave to appeal have already been dealt with?
My Lord, if I can just go to our application in that respect, I just want to quickly go on to quickly highlight the issues.
Yes, do I find that's the...
Okay. Well, in our...
Yes, is that under the heading in case lines?
That's correct.
046, any other
112.
interlocutory application?
Yes, 112, yes.
Yes.
046 112, that's correct. My Lord, that application starts off with, or the affidavit starts off obviously to first attend to the representation issue, to ask permission that I need to address the court on behalf of Liberty Fighters Network as well. That is a practice in the High Court that it is, unless the court grants that right from its own movement, an applicant should actually come forward first with such an application. So we just that is basically just out of practice that I've been involved in from before.
Yes, thank you. I think I've heard you on behalf of the second applicant previously in any event. So let's proceed from that basis rather than exclude a party.
Okay. Thank you very much, my Lord. We have highlighted...
yes, from paragraph 5.
Yes, we have highlighted that we were... take into consideration that we were obviously always guided by the legal advice of our legal representatives, which have subsequently withdrawn as attorneys of record. So in that respect, they have indicated that as we are dealing with that issue in our affidavit, that paragraph 5.2, we said that at that stage I was advised by our legal representatives that we should wait for the court's judgment in that regard in order to determine whether it was indeed necessary to also file an application for leave to cross appeal. Or not.
Mr. De Beer, let me interrupt you there, because you're also not a complete layman regarding litigation. So the customary thing is that all attacks on a court's judgment, which are to be taken on appeal, customarily are heard simultaneously, because the one party will say, well, court, you were wrong, give me leave to appeal. Another party will say, you were right in that respect, but wrong on something else, give me leave to appeal on something else. Now, the issue that you seek leave to appeal on is the declaration of a state of disaster, which I found was then reasonable. Now, if you were to be of the view, or the applicants be of the view, that I was wrong, then one would have assumed or accepted that such an application for leave to appeal would have been done at the first instance, particularly at the same instance where the other applications for leave to appeal are heard. I have difficulty understanding the advice which you say you relied on, but say you were advised to wait until the judgment and leave to appeal on 30 June. Why wasn't that application then immediately thereafter delivered?
My Lord, we are in a period of exceptional circumstances because of COVID-19. This court roll was inundated with one after the other similar applications that we had. So it did not make sense, as I understood and also discussed with our legal representatives, that it did not make sense if we pursue something from our side which could be dealt with in, like for instance, in the Freedom Front Plus matter, where they also tried or attempted, as we understood, to attack the declaration of the national state of disaster. Yes, their argument was a bit different, because they were actually trying to say that the Disaster Management Act or certain provisions made in it was unconstitutional, and hence, because of that, the declaration of national state of disaster was not sufficient or could not have been enacted. So, as my Lord and also described in the heads of argument of the respondent, in that matter was heard before a full court, which obviously carries a bit more weight than respectfully said one judge before a court, and so we did wait for the outcome of that application, which was very detrimental in determining whether the arguments that we would put forward to the court is either the same or could be different. It turned out that it was actually not helpful enough because that matter was actually dismissed. And as I have also identified in our heads of argument under the subheading of the Freedom Front Plus case, we actually identified several matters which we respectfully don't agree with the court or the full court in that matter. So if we go on with our the affidavit that I've submitted in support of this application for condonation, I've also indicated that in paragraph 5.4, the issue about the 14 days that were given to the judge, to the respondent, sorry, in order to comply with the order granted on the 2nd of June. We were hopeful that the measures that would be enacted would be of such a nature that it could even bring an end to the lockdown, and the respondent and the government would basically come to a different conclusion and get us out of the lockdown. So everything about COVID-19 was totally different than we were used to, or in the normal way of dealing with matters in this court before the pandemic outbreak. So in that sense...
No, I have the argument then. All right, that's the argument in paragraph 5. If condonation is granted and one proceeds then to the application for cross appeal, on what ground do you say there are sufficient grounds or reasonable prospects on appeal that another court could come to a different conclusion?
My Lord, I just quickly want to open my heads as we have addressed it in there. I beg your pardon, my Lord. My computer is a bit slow today. The applicant or the applicants refer to paragraph 5 of the heads of argument, obviously.
Yes.
We indicated there are basically in paragraph 5.2, we've highlighted 3 points that is a bit different than or we should actually rely on. Number one, we said that this matter was dealt with as urgent on the 28th of May and should be finalized as quickly as possible before the Supreme Court of Appeal as well. For that reason, the cross-appeal can be dealt with at the same time as the appeal of the respondent as an extensive application to the Supreme Court of Appeal requesting leave would postpone finalizing the actual dispute with at least another 6 weeks because of the matter of the way the processes work, and taking into consideration that the Supreme Court of Appeal does not actually make provision for urgency. Secondly, we said that if the declaration of a national state of disaster is confirmed by the Supreme Court of Appeal to be unconstitutional and invalid, then it will resultantly mean that all Disaster Management Act regulations will automatically be invalid, as the Kochta minister then never had the authority to have published that. So then the dispute involves vital constitutional raised issues going to the heart of our democracy and constitutional liberties, which in itself justifies leave to appeal. But very importantly, the answer also relies to Section 17(1)(c) of the Superior Courts Act, in which we say that it would respectfully be of paramount importance that leave should be granted to the applicants to cross-appeal in order to allow the Supreme Court of Appeal to have all relevant facts and arguments before it, which would have an effect on reconsidering the declaration of unconstitutionality and invalidity in relation to the DMA regulations. This, the applicants believe, would justify leave to cross-appeal inter alia in respect of Section 17(1)(c). Then we further highlight the issue why our case is also different than the Freedom Front Plus case. Why would we advance?
Yes, and you have the quotation in paragraph 5.12 where that full court said it dealt with the matter limiting its consideration to the attack in that application. That's the unconstitutionality attack of the section.
That's correct. Yes, my lord.
And do I understand you correctly that the current applicants before me, your case is irrespective of constitutionality of the section should not have been invoked. There were other measures to be invoked.
That's correct, and we've also addressed that extensively in the heads of argument. Very importantly, which is of paramount importance further, is that we are saying, and the respondent failed to address that specific issue in her answering affidavit in the main application. We have specifically said that it's very strange how the minister could have evoked a national state of disaster, in the sense that by the time it happened, and even by the time we went into a full lockdown on the 27th of March, the WHO, we as a state party to the World Health Organization, South Africa complies to the so-called ICD-10 coding system of the World Health Organization in order to present statistics to the World Health Organization in respect of various and all diseases. So we said that we have a problem in the sense that the ICD-10 coding system for COVID-19 never existed until the 1st of April. So we wanted to know, and the respondent failed to answer that by the time we went into a hard lockdown, it was claimed, as I can remember, there were something like 1,000 cases of this claimed disease. But unfortunately, by then, there was no system in order to evaluate those cases until the 1st of April, when the WHO coding system came into operation. So we are saying that it's also clear from the Freedom Front Plus matter that under the circumstances, it seems that even the Freedom Front Plus struggles to get information from the minister in order to justify what evidence and what circumstances, because South Africa is so unique. South Africa could not have just simply relied on the World Health Organization to tell us as a sovereign country, you must go into lockdown. And in any event, the World Health Organization never told any country that you must go into a lockdown system or declare a national state of disaster. So
but the question then is there a reasonable prospect that another court on appeal, well, the other application is to the Supreme Court of Appeal, will come to a different conclusion on the facts of this case than I have come initially?
My Lord, we believe respectfully so, definitely. I think from the perspective of what my Lord have addressed in the judgment itself in respect of the International Health Regulations Act of 1974 specifically, my Lord respectfully in error said that, for example, that there is no or basically it comes to the fact that there are no regulations. If I can just quickly go to that part, my Lord have specifically addressed in that regard. Unfortunately, it seems as if there was a miscommunication when I've argued the matter in court that day, in the sense that the World Health Organ or the International Health Regulations of 2005
yes,
is actually invented and have been produced in such a way that that any disease can be targeted by it, and it also makes provision for public. It refers in the definitions and within the context of the document, it refers to public health emergencies. So it means that if the president, we believe, in terms of the International Health Regulations, Section 3, 1 and 2 of it, could firstly have, for example, included by mere proclamation the new set of International Health Regulations to make it current. And secondly, he could have, as the leader, as the head of the executive in South Africa, could have then taken the lead from his side in order to proclaim regulations similar to those, and hopefully not to the extent of threatening human rights violations, because in terms of Article 3 of the International Health Regulations, there may not be any tampering with human rights. So we believe that if government have rather chosen that route, and that has not been properly addressed in the Freedom Front Plus case. So we do believe that the arguments that we will advance to the Supreme Court of Appeal, if leave is granted, is much different than the ones currently before the full court, or that was before the full court. And it's basically going into the actual reasons why the International Health Regulations Act was promulgated, and also the 2005 International Health Regulations itself.
Yes, the quotation in footnote 25 of your heads of the IHR, is that a quotation from the International Health Regulations 2005 itself?
My Lord, which point is that? Sorry.
Footnote 25, which you refer to in paragraph 5.16 of your heads. Is that a quotation from the IRH itself?
That's indeed so, my Lord. And I've also uploaded the International Health Regulations of 2005 onto the list of authorities as well, for my Lord to have
thank you.
Direct access to that. So if one reads that, it made provision for everything. It was designed to cope with anything. And in that respect, I've also referred to Article 3, which is so very important, because Article 3 specifically said that notwithstanding that there is a health threat, not only to your own country, the public, but also to the international community you as a state party is part of. We believe, after considerable conferences that were held in order to compile this set, that it's not necessary to tamper in any way with basic human rights. That is what Article 3 of those international health regulations say. So
Yes.
that alone says that...
That's the basis for you for motivating the possibility, reasonable prospect of a different conclusion.
Yes.
So you say in summary that it wasn't necessary to invoke the DMA, the Disaster Management Act.
It was not, in terms of the criteria met in terms of Section 27(1) of the
Disaster Management
Act was not fulfilled, because in paragraph A thereof it specifically says that if the executive have got something else to work on, then that must be obviously used. And it seems as if the respondent in that respect did not take that route first. And as we can also see, not only in our case, where we struggle to get information from the respondent side, even the Freedom Front Plus obviously also had difficulty to get information from the minister in order to justify what was going on at that stage in order to have this decision made.
All right. Address me then on your Section 18.3 application. The respondents say the requirements of the Act have not been met. Section 18.1 of the Superior Courts Act says, subject to subsection 3, unless the court under exceptional circumstances order otherwise, the operation and execution of an order is then suspended. And 18.3 then says a court may only order otherwise if the party who applied to the court to order otherwise in addition proves on a balance of probabilities that he or she will suffer irreparable harm and that the other party will not suffer irreparable harm. Now, the respondents argue that those requirements have not been met.
My Lord, in the founding affidavit to that application, we have excessively addressed each and every one of those points under separate headings. The most important matter there is that why is it now necessary to, while there is an appeal pending, what exceptional circumstances are there in order to justify that the court should actually now intervene in helping the applicants and effectively also in the interest of the public? Paragraph 6 extensively of our heads address the issue, but firstly, because it was specifically raised by the respondent in the answering affidavit to this application, and also extensively addressed in the heads of argument of the respondent, we had to come in and unfortunately open a Pandora's box at this stage, which I have raised in the leave application, but at that stage my Lord said, no, you are wrong. There was no suspension of the order because of basically the enactment of Section 18.1 specifically. So in paragraph 6, 6.5, under the subheading, did the filing of the respondent's leave application suspend the execution and operation of the court order of the 2nd of June? We basically say respectfully no. And we unfortunately at the time when that matter was heard, I've referred to the Nichols case. that was heard in the High Court in the same division. But for some reason, we did struggle, and I did struggle to get the actual original Constitutional Court case, which is the new Clicks case. That was before the court, the Constitutional Court, I think, way back in early 2000s. And but in terms of
that's the argument that the finding or declaration of constitutional invalidity is not suspended.
That's correct. So yes. That option in terms of the leave application, in terms of the Section 18.3 application, is very, very important. But what the Constitutional Court said in that application is that the Constitution of South Africa is and remains the supreme law of this country. It says further in Section 172(1)(b) that the court can suspend the operation of the judgment, as the court did in the order of the 2nd of June for a period of 14 days. And that court order, or the Constitutional Court in that case, specifically said that it's managed, or that whole suspension is up to the court in terms of the authority provided in terms of Section 172(1)(b), and it's up to the court who granted the order to actually say whether leave to appeal should be suspended pending the outcome or whether the operation of the judgment should be suspended pending the outcome of the leave application. It specifically addressed the issue of that a leave application. I did quote the relevant parts in it.
Yes, I saw that in paragraph 6.11.
That's correct. And I've highlighted the important ones. In paragraph 20 of that judgment said that this provision enables a court to regulate the effect of an order of invalidity pending an appeal. A litigant who considers that it would be just and equitable for an order of invalidity to be suspended pending an appeal should make timeous and appropriate application to the court considering the application for declaration of constitutional invalidity, and it goes on. But how we interpret it is that...
Mr. De Beer, the difficulty with this matter also is it's almost a moving target. The facts you referred to in your affidavits have already changed. Now, if one has a look at the judgment you quoted and say, well, a court can ameliorate the consequences of such a declaration in the interim. The order of unconstitutionality was not on the basis of it being ultra vires, for example. It was simply that the balancing act of competing rights in terms of Section 36 of the Constitution was not undertaken by the minister. It was just a one-sided declaration. That was the finding. Now, subsequently, the regulations have been amended from time to time. Now, to an extent, one might argue, or someone might argue, that entails then a consideration of other rights or weighing up of different rights. And it gets closer to the respondent's argument to say, well, why should there be a Section 18.3 order in the interim pending appeal? Because the question has largely become, or materially, as they say, become moot, because we're now in a different lockdown phase. We're now in lockdown 2, and a lot of the complaints or complaints raised have been addressed, or irrationalities have either been addressed or fallen away completely. Is there then still a need then for an order in terms of 18.3 is the question?
My Lord, the 18.3 application can also be considered as a normal application that is brought before the court, and because the court has got the authority to regulate its own processes and come to conclusions and decisions which is justifiable under the circumstances. Hence the reason why we ask also the court for alternative relief. If it is so that an
Mr. Beer, sorry to interrupt you again, but this isn't procedural. The court can regulate its own process, but this is not procedural. The consequences of an order in terms of 18.3 will go far beyond procedure.
My Lord, if I can maybe address the special circumstance or the exceptional circumstances, I have
yes, that's one of the
everything.
factors that this section requires you to indicate. That's in
correct.
paragraph 6.15 of your aids.
That's correct. We have
Yes.
identified 4 critical exceptional circumstances. The first one
Yes.
is obviously we are in an exceptional time. COVID-19 is exceptional, and everything that flows from it is unfortunately exceptional. It has made our lives totally different than it used to before the lockdown. Our lives have been changed detrimentally in the sense that our basic human rights are now regulated, obviously, in such a way that it does not make any sense to many of us. Hence the reason why we brought the application in the first instance. So that's the first point, that and everything that flows from these exceptional circumstances of COVID-19 should then be in the discretion of the court, as was held in the Leashing case in the Constitutional Court, specifically what is meant with exceptional circumstances. It's in the discretion of the court under these circumstances that we find ourselves in now, whether it is just and right to allow that there, or to come to a declaration that there is indeed exceptional circumstances present. Then the point 2, which we have raised, is that the constant
changing landscape, yes.
That is totally confusing, not only for jurisprudence, for the court system to function, but it seems as if the respondent is of the view, as I understand the heads of argument of the respondent, that every time when the regulations change, then any application already busy challenging those regulations will automatically become moot because you are immediately in a new situation. We said, but it cannot be. The law cannot be interpreted in that way. It simply does not make any sense that we say that there were 2 sets of main sets of DMA regulations. It was a set published on the 18th of March, which have subsequently been changed, and then on the 29th of April, a second set, the current set, which have just been chopped and changed all the time. So we are saying that it's not new regulations we are dealing with. It's got the same substance, and I think my Lord have specifically addressed that issue in the reasons for judgment in both the leave application as well, to say that it's carved from the same DNA. It's part of the same umbrella. So even if the minister is changing the regulations to an extent that we are now suddenly in level 2, bearing in mind that as the current situation stands, the minister can make a proclamation to go back to any one of those in any event. Hence the reason why it's so important to deal with everything that is in front of the court. It's part of the law. It's there now to address, and I can't see respectfully any reason why this court should not be able to come to a conclusion that irrespective of level 2 regulations, which seems to be an attempt maybe of the respondent to settle this specific case that is before the court now, in order to alleviate through the changing and chopping and changing of the regulations, she is basically putting herself in a more favorable position before the court. She believes, it seems, that the respondent can make regulations which can basically write herself out of any judgment. That is the fear that we are sitting with, and that is definitely
well. Apart from the fear of a litigation of a particular case, the response is that the adjustment by way of amended regulations is an adjustment to a changing circumstance, and a circumstance which is ever fluid. It's not necessarily a court case, and it's not as if the minister says, well, I don't want to be held liable in terms of the Liberty Fighters Network case, and therefore I'm going to change the regulations. She says, well, I was advised otherwise by virtue of the facts that have changed and by the advice of the various committees.
My Lord, that is a very important point that my Lord is raising. Last night, when I've intensively studied the Freedom Front Plus case in order to prepare the heads of argument in respect thereof, I've noted that, yes, it seems as if there are no any records of those decisions that, or the information that the minister is actually using to constantly change this. We are saying that yes, it seems as if that court case is still pending because the court in that matter is still waiting for records to be produced. And in a similar sense, that if the court is of the view that the constant chopping and changing of these regulations is because of changing measures, then we would like to then ask this court, if the court is tentative to make a final ruling on this application, to then, under those circumstances, compel the minister to actually to produce those records to this court, so that the court, because this is such a last shot for the people of South Africa and the applicants to try and get something out of the order that was granted in our favor on the 2nd of June, to try and do give more relief to us before we are going to get plastered against the walls of the Supreme Court of Appeal, which could take
Mr. De Beer, can I ask you on that point something else? We're getting close to the end of that paragraph of yours as well, on exceptional circumstances. What concerned me in the initial application as well is, and that'll be the consequence of your 18.3 application, if successful, it'll mean that there are then no regulations in place. Wouldn't that absence or that regulatory void be to the detriment of the public, which you say public interest should be concerned? Let me put it differently. If there are tomorrow no regulations, but the danger and the impact of the virus is still present, wouldn't that be more harmful for the public than some measure of regulations or measures of addressing the impact of the virus?
My Lord, we have addressed the strangeness of the COVID-19 disease in our replying affidavit by referring to a recent national NICD report by Professor Cohen, where she now suddenly says that the 10 million expected flu cases in South Africa has now been reduced to only one reported case in June in Gauteng. Now we are saying that, but what happened to flu? But if we go to the arguments of this learned professor, she said in the beginning, I think in April, she said, we did also refer to that specific part in our affidavit, whereby she said that the symptoms of COVID-19 and flu are similar, and she, or the NICD, foresee a problem in identifying COVID-19 as a disease coming into the flu season. And now they are saying that for the first time in 36 years, we will not have a flu season because of the measures taken for COVID-19. Where we are saying that now it seems as if the measures that were implemented actually basically reduced the flu in South Africa. We all know from the day when we were born to only one case, and now suddenly there are thousands of cases for COVID. We are just saying that couldn't it now be that the normal flu that we are used to have, unfortunately those symptoms have been confused with the symptoms of this new claimed COVID-19, because it does not sound possible to believe that there can only be one reported case during June in Gauteng for the flu. I had the flu a couple of months back. I know that because I'm used to the symptoms. And so did other people that I know as well. And now suddenly the reporting is much different. So in that sense, we don't believe, and we have also attached to our replying affidavit indications in the media that the government have actually said that we've got sufficient space. We are now actually removing field hospitals that we have created. So there is no threat at this stage. So we believe that if there are, for example, my Lord, if the regulations are null and void tomorrow, as my Lord suggests, could maybe happen if the court finds in our favor, but when judgment is delivered. We are sitting with the options that people will in any event, I believe, that people will in any event continue with the normal procedures that they are used to and comfortable with. Because there are people who are still worried and fears COVID-19.
All right. But on that point, can I then summarize so we can also progress with the application? So you say that 1, condonation should be granted. 2, leave to cross appeal should be granted. But then 3, you say, in terms of section 18.3, the order of 2 June this year should be implemented immediately. Now, that order did not deal with the regulations which had been promulgated subsequently. Even if that order is granted, would that not leave the level 2 regulations still in place?
My Lord, if there are no main regulations set, meaning that if there is no regulations promulgated in terms or dated the 29th of April, then it means that anything else promulgated under will automatically not be there. So
I see, yes. And that's what you asked in the initial application, that all regulations were declared unconstitutional. And you remember, you refer to the dates from the inception thereof.
That's correct, my Lord.
Yes,
so,
yes. All right, now then I'm with you.
And in terms of the order specifically granted, the order said that the DMA regulations promulgated under the DMA Act is declared unconstitutional and invalid. So it did not refer to a specific level. And the order, that is the key part of the judgment, obviously. The order is the one that needs to be interpreted. So we interpreted on the bounds of the court order itself that all regulations, even those from the 18th of March, if ever one can go back that far, is automatically invalid because of the fact that the court found that it was irrationally created in the first instance. Then on point 3, we have we said that yes, the administration of the court at this stage of COVID-19 is really difficult. We've even referred to an international case in the Supreme Court of Victoria, where exceptional circumstances in a specific bail application were actually dealt with, and even internationally in that court, it said that because of the problems experienced with hearings that are being postponed and the court not functioning in the way that it should be, we unfortunately foresee that we could be trapped. Basically, as long as the national state of disaster continues, in the Supreme Court of Appeal not even moving one step forward. That is a strong
Mr. De Beer, but that submission is not factually supported. In fact, this court functions, the other division of this court functions, the Supreme Court of Appeal functions. In fact, the Supreme Court of Appeal reported that in the past term, or this term actually, it heard more matters than it had heard pre-COVID-19, and in fact, the virtual hearing thereof assisted it. In fact, it said it exceeded its previous number of hearings per term.
My Lord, I'm not familiar. If my Lord says that is the experience of my Lord during this period, then I do believe it. It would just be interesting to know where the self-represented litigants actually fit in. Because, my Lord, I have personally experienced an extreme difficulty to actually access the system. From my side, not being represented at this stage by a legal practitioner. So I've also heard of a case where a matter was heard urgent, and she did go to the court room, but she was refused access, and the matter proceeded virtually in her absence. So those are matters that we need to look at, and especially the Supreme Court of Appeal does not make provision to speed up the process. There is a specific, the regulations, the rules of the Supreme Court of Appeal is, for example, making provision that the record of this court must be properly placed before with the registrar, or lodged with the registrar within 3 months. So there is nothing at this stage which prevents the respondent to lodge that record, for example, the last day of the 3 months. So then we are already...
All right. No, I understand that's your argument or your concerns regarding the appeals. Of course, restrictions on access to justice, particularly by unrepresented parties, is of concern to this court. But I can tell you that I have heard urgent applications where people were in person, and in fact, the remote hearing have assisted people where, for example, one of the parties was in George and could not even come to Pretoria, which he would have been required to do had there not been virtual hearings. So in some instances, the virtual hearing directives imposed can even assist parties. But I take your point. That's the point in paragraph 3 of 6.15, that the restrictions impact even on rights such as access to courts.
Indeed, my Lord. And then point 4 that we specifically highlighted is the fact that there's an extensive public interest in this matter.
That's the whole case, actually. The whole impact of the regulations.
So the whole country is affected by the fact that our court order that was granted in our favor on the 2nd of June has been pending. That case was heard as urgent because the court believed also and agreed with us that the circumstances demand urgency and need to be addressed as a matter of urgency. And now, unfortunately, the Supreme Court, the appeal processes that are currently underway is now hampering the urgency, and the only way in which an applicant can now get relief in some way to fit his urgent matters, as was already determined and agreed on in the first instance, is by way of this application. This is our only shot at the target now. Until if this application fails in any respect to bring the relief that we are praying this court to grant to us, or did grant to us, but now is apparently suspended pending the outcome of the appeal. This is we're going to continue with these regulations and the human rights violations intact in it. We've identified that currently there are only two sets. Regulation 3.2 of the 29 April set of regulations have basically made implicated that there are going to be 5 levels. So the minister already had in mind that she's going to have 5 levels. But unfortunately, level 5 and level 1, both of them have not been introduced, have been promulgated yet. It's only level 4, 3, and 2. So we are still waiting for the trump card, either level 5 going back to level 5 at some stage, or we are going to a lower level, whatever that might mean, a level 1. So we still don't know. Even if we have been in lockdown for 5 months, the minister have still not come out and made level 5 and level 1 regulations public. During this period, if she managed within 3 days from the 15th of March to produce a full set of regulations within 3 days, which was promulgated on the 18th of March, we believe that the minister is capable indeed to quickly and efficiently have a proper set of regulations which is this time properly aligned with the Constitution. Each level, that level 4, 3 and 2, all of them have the same paragraphs. Most of them even have the same paragraphs. It refers to the same violations of the Constitution in the basic human rights, the Bill of Rights. And we are saying that there should not be any restrictions, because if the international health regulations of 2005 specifically say, after there was an international conference after conference to discuss and implement or approve those regulations, if those regulations say that it's possible to implement those regulations and those measures without any hampering of basic human rights, I honestly believe, and this is the case of Liberty Fighters Network as well, that this whole matter, or it is possible not to restrict our human rights. It is possible to allow us ourselves as human beings.
That's back to the cross appeal grounds. Yes. Thank you, Mr. De Beer. I thank you for your heads. They are extensive and they are very complete, and thank you for the additional authorities.
My Lord, sorry, can I just target just one very important matter? The issue of the mask wearing. It is now, unfortunately, something that one can be arrested for if caught without one in public. We have extensively addressed the issue on it in our founding affidavit, why it should be a choice to the wearers of it, and that it can even be not healthy for people to wear it. So we are saying that the option of wearing a mask should be a decision that a person takes himself, taking into consideration that we are saying that those wearing of masks, for example, which have been before this court from the beginning, that part, is really something that I have addressed the issue, for example, sending my children to school with a mask. There is a extensive research which have not been protested by the respondent, to actually say that it can actually do more harm than actually good.
Yes, I saw that in the papers, yes.
When my lord reads the papers, just take into consideration that very important matter as well, and I'll be waiting for the to answer in reply then. Thanks.
Thank you, Mr. De Beer. Mr. Trengo, I've also received.
Lord.
Trengo, I've also received the respondents' heads. There is an issue which Mr. De Beer raised in his heads, which he hasn't debated, which I read and saw actually prior to his heads, is why is the minister's affidavit not properly commissioned?
The policeman used the wrong stamp. That's all. But the minister filed a supplementary affidavit this morning in which she says that her original affidavit was properly deposed to, but the policeman used the wrong stamp, and she then again confirms the original affidavit.
Oh, all right. I haven't seen the supplementary affidavit. You say, but it has been uploaded.
It's at page 015-1.
Yes. Thank you, Mr. Trengo. Yes.
Lord, let me start with the leave to cross appeal. Firstly, the delay was excessive, and it was deliberate. They tell us that they delayed because of advice from an anonymous person, an anonymous lawyer, for unexplained reasons. It was simply advice to wait until the Freedom Front case and then for other reasons. But it's not explained on what possible basis can you ignore the court rules because you have decided to wait for other things to happen. So there is no denial that they knew what the time bar was, and there is no rational explanation for why they didn't meet that time bar. Mr. De Beer came to court, sat in the hearing where our leave to appeal was argued, knew that he was subject to the same rule, didn't say a word, and waited another while before he launched an application. And even then, even after the Freedom Front judgment was given, they took another 2 weeks before they launched their application. So the delay is excessive, it's unexplained, and even if they got that advice from some lawyer, one sometimes has to bear responsibility for the wrong and irrational advice of a lawyer. We submit with respect that the prospects of success are also hopeless. Mr. De Beer doesn't address the test for the review of prospects of success, and that's a test of rationality. The question is not whether you think that other means would have been better. The question is whether the minister's decision was rational. The decision was one taken at a time when every other country in the world was doing exactly the same thing. So there can't be any basis to suggest that it was irrational to declare a national state of disaster. Mr. De Beer says that the international relations were available to government, and therefore the minister was not entitled to invoke the Disaster Act. But that's wrong for two reasons. Firstly, the purpose of the international regulations is to spread, to combat the international spread of disease, not to address domestic disaster. The Disaster Act, on the contrary, specifically allows for a state of disaster to be declared if the disaster is caused by disease. So it is catered, it is specifically designed inter alia to cater for domestic disasters caused by disease. So that's the first point. But the second is, it is for the executive to make that choice and not for Mr. De Beer. He invokes Section 27 of the Disaster Act, which he says allows a state of disaster to be declared only if there is no other means available. But that's not correct. Subsection 27.1 says that the minister may declare a national disaster, A, if existing legislation and contingency arrangements do not adequately provide. That's the provision on which he relies. But it then goes on to say, or B, other special circumstances warrant the declaration of a national state of disaster. So it is not correct to say that she's disqualified because the international regulations were available to her. There is an added consideration, and that is that the same attack has been made in the Freedom Front case. What happened in that case was that the Freedom Front launched an application for a very long list of orders. A number of them were directed at the declaration of a state of emergency. But the Freedom Front demanded two incompatible things. The one is a hearing within days, and the second was full disclosure of the underlying record. And it was made clear to them, you can't have both. You can have a quick hearing, or you can have the record, but it will take weeks to put that record together because it comprises thousands of documents. So the compromise that they opted for was to proceed urgently with some of their prayers, but to stand over for later determination some other prayers. Those that stand over include prayers for review of the declaration of a state of emergency, not state of emergency, state of disaster. So the very issue which Mr. De Beer wants to take on appeal is already before the full court and is being processed on the basis of a record which is to be produced and supplementary affidavits that will then be filed in the ordinary course. We submit that that's an additional reason not to allow leave to cross appeal, because the self-same matter is currently before the full court and is being subjected to a far wider and more thoroughgoing investigation than Mr. De Beer's application. So for those reasons, we submit that the delay is excessive and is unexplained. There are no prospects of success. And thirdly, it's not as if the challenge will die. The challenge is alive and well and before a full bench of this court, where it is being subjected to a far more comprehensive test than is suggested in this case. May I just qualify all of that? As I say it, I speak as if I know exactly what's happening in the Freedom Front case. I was last involved in it at the time when the matter was argued and the judgment was given. I've not been party to the subsequent process, except to know that what was envisaged was that the ordinary review process would be followed and implemented. So, my Lord, we submit for those reasons that the leave to cross appeal should be refused. If I may then turn to the Section 18.3 application. Mr. Beer makes an argument which we submit with respect is not correct, but if it were correct would be self-defeating, and that's this. He says that the appeal does not suspend this court's order. But that is not correct. The Section 18 of the Superior Court Act doesn't make exceptions to the rule. But if he were correct, then it would mean that a Section 18.3 order would be neither necessary nor competent, because there is no suspension in the first place. So we submit with respect that that argument does not avail him and is incorrect. What the court was dealt with in New Clicks and the cases that followed it is the implications of the doctrine of objective constitutional invalidity. And that doctrine says that if an act is unconstitutional, then it is objectively invalid from the moment of its birth. But its status can only be judicially determined, and that judicial determination is only finally made at the end of the line. And the court can then retrospectively regulate the impact of the declaration of invalidity. But it never said that Section 18.3 only applies to some court orders and not others. It applies to all court orders, and it provides for a default rule. These days, a very strongly embedded default rule that court orders are not implemented until they become final. For as long as they are subject to appeal, the default rule is you don't implement the judgment unless there are exceptional circumstances, proof that there would be no prejudice to the respondents, and proof that there would be prejudice to the applicant. Mr. Beard doesn't address any of those. Of those three requirements, he addressed one, and that is the exceptional circumstances. But the exceptional circumstances on which he relies are indeed exceptional circumstances, but not exceptional circumstances which warrant departure from the default rule. In other words, what I'm saying is that those exceptional circumstances make it all the more important not to interfere with the default rule, rather than to depart from it as he would want. And that is so for this reason. He says, for instance, that we're in a time of COVID, which is a very unusual pandemic. Yes, that is true. That is very unusual. But it makes it all the more important not to overturn the executive's management of the pandemic by a judgment which is not final and which may be overturned. In other words, that consideration makes it all the more important not to meddle with the default rule, but to wait for the judicial process to come to a final judgment before you overturn the executive's management of the disaster. He says the disaster regulations are constantly changing. Yes, that is so, and that is another consideration why in this case there is no warrant for interference. And my Lord, may I deal with it while I'm busy with it? Just deal with the implications of the court's order and an order under Section 18.3 in the light of the ever-evolving disaster regulations. The disaster regulations, my Lord, comprises a number of chapters. There is firstly Chapter 1, which is a chapter of definitions. Then there is Chapter 2, which is a chapter of general rules, which generally is a little bit of tinkering from time to time, but those general rules remain constant regardless of the level, lockdown level. But then after Chapter 1 and Chapter 2, there are chapters providing for Level 4, Level 3, and now Level 2. And what this court's order did was to declare invalid all the regulations in existence at the date of the order. And that was Chapter 1 and 2, the definitions and the general rules, plus the Level 4, plus the Level 3 regulations. But since the court's order, in August the other day, the minister promulgated a new chapter with Level 2 regulations. And they are unaffected by the court's order. So that if the court were to make an order under Section 18.3 today, its effect would be immediately to strike down chapters 1 and 2, the definitions and the general rules, plus the Level 4 and Level 3, which are still on the statute book, and Mr. De Beer is correct. They're not completely dead yet because government may still return to those levels, but they're not in operation at the moment. But it will leave unaffected the Level 2 regulations. So, my Lord, your Lordship mentioned, and we submit with respect quite correctly, that the fact that there there have been level 2 regulations promulgated, and that they cover largely the same ground as the level 3 regulations, but in different terms. New rules have been promulgated. But to a very large extent, the purpose sought to be achieved by Your Lordship's judgment has already been achieved, because the Minister has, in promulgating the level 2 regulations, had to go back, think about them again, think about their formulation, and redraft them. So that purpose has to a large extent been achieved. But on top of that, putting the order into effect immediately would not affect level 2 regulations, except that it would strip them of the definitions in Chapter 1 and the general rules in Chapter 2. So it would generally create, disturb the operation of those regulations, but it wouldn't by any means put an end to the level 2 regulations. The Minister would presumably have to urgently re-promulgate the definitions and the general principles, but for the rest it would make no difference. So we submit with respect that there is no compelling reason to put the judgment into effect forthwith, because it will cause some disturbance, but it would not knock out the regulations which Your Lordship found to have been unconstitutional, namely the level 3 and level 4 regulations. They are not in operation at the moment, and there's no reason why their validity shouldn't stand over for determination by the SCA. My Lord, I'm afraid I can't hear you. I don't know whether your audio is on.
I'm sorry, Mr. Trengove. I say, unless, of course, there is notionally tomorrow or next week or whenever a return to those levels, then the concerns raised would, of course, then arise again, even though the appeal has not yet been heard.
No, I accept that, and for that reason, my Lord, we don't contend that the issue has been completely mute. I think we used moot. We used the word like substantially or materially or whatever. So we accept entirely that it's still on the statute book and will become applicable again if the Minister promulgates a reversal into one of those, but only then. So there is a possibility, but not a likelihood at all that that would happen. Mr. De Beer did not address the absence of prejudice to the respondent and the probability of prejudice to him and the public if the order were to be granted. An important consideration to bear in mind when one considers irreparable harm to government and to the public is what the Constitutional Court in the Outer case called separation of powers irreparable harm, or separation of powers prejudice harm. And that is that a judicial interference with executive exercise of executive powers constitutes what it called separation of powers harm. Now, there are, of course, cases where it is good and appropriate that there be interference with the executive powers, and that executive separation of powers harm is justified. But one needs to bear in mind that when one is dealing, particularly in that case, in the Outer case, they dealt with an interim interdict. In this case, it would be the same consideration, where one is dealing not with the ultimate determination of the case, but with an interim arrangement. What one needs to bear in mind that will inevitably have separation of powers, entail separation of powers harm. And we submit with respect, my Lord, that there is absolutely no reason in these circumstances that I've sketched why the default rule that court judgments are not implemented before they become final, why that default rule shouldn't continue to apply. Because the immediate implementation of the judgment will immediately bring about separation of powers harm, we submit without justification, because it would, as we've said, not materially affect the level 2 regulations which are enforced.
Mr. Trengove, just assist me with the following. In dealing with that aspect, the minister dealt with harm to herself, and there were extensive paragraphs in the affidavit saying, look, it'll take too much time and we have to re-audit everything and decide, and we can't do it in so many days. And there are 3 various scenarios set out of whether the 14 days or 10 days or 4 days and so on. But that's not real harm. That's just saying it'll be difficult for me to reconsider. And if she wants to elevate that to a harm to governmental functioning, then I fail to see that. And of course, one should be careful and mindful not to cross the boundaries of separation of powers. But if the order is reconsider and take into account the other entrenched rights in the Bill of Rights in each regulation that you make, then that's not running government or being prescriptive or being overstepping on government's executive function. It is just merely saying comply with the Constitution.
Yes, my lord, but that can be said of every court order court order finding that executive action is unconstitutional and invalid. What OUTA describes as separation of powers harm is judicial interference with the exercise by the executive of their executive functions. And it doesn't matter whether it is easy for them to comply or difficult for them to comply. There is separation of powers harm whenever the judiciary interferes with the exercise of executive powers. And remember, in this case, we're not suggesting for one moment that interference won't be justified or untoward one day when there's a final judgment, because that's entirely appropriate that the executive should, that the judiciary should, when there's a final judgment, determine what is constitutional and what is not, and the executive has to fall in with it. But we're at an earlier stage, we're at the outer stage, where you consider what should happen until the judicial process has run its course. And we submit that in those circumstances where what the implementation of the court order will mean is to strike down chapters 1 and 2, which was never really subject to attack, and will then also strike down the level 4 and level 3 regulations, which aren't really in force at the moment. And what it will do is to preempt the minister's right of appeal, because you will compel the minister, pending the outcome of the appeal, to comply and implement the court order. Well, once that's been done, there is very little point left in an appeal, because the horse will have bolted. You will have compelled the minister to comply, regardless of the fact that she has not yet exercised her right of appeal. So we submit with respect that there would be significant separation of powers harm in that you would compel the minister to comply with the court order, despite the fact that the court order is not final and may be overturned on appeal, to no end. Nothing significant will be achieved by requiring the minister to reconsider and promulgate the levels 3 and 4 regulations.
Yes.
And by the same token, there is no irreparable harm to the applicants if the implementation is delayed, because, again, effectively we are living under level 2 regulations, which are unaffected by the court order. And so for that reason, my lord, we submit that the applicants have not satisfied the requirements of Section 18.3. Their exceptional circumstances militate against immediate implementation and does not support it. There will be irreparable separation of powers harm, and they have not shown irreparable harm on their side. So that we submit that far from complying with all three of those requirements, they've not met any one of them. And as far as costs are concerned, my lord, we accepted the BioWatch. Well, let me say, if any leave is granted, then obviously costs should be
cost in the appeal.
In the appeal. But if leave is refused, we don't seek costs, and Mr. De Beer doesn't have costs. So it doesn't seem to me that a cost order is called for, regardless of the outcome.
Yes. Thank you, Mr. Trenko. Thank you for the heads as well. I've received them. They are equally lucid and complete.
Thank you, Mro.
Thank you. Mr. De Beer, before we carry on, I see Mr. Motopeng has joined us. Now, Mr. Motopeng, if I recall, is one of the amici previously, the Holabon Renaissance. Now, the role of an amicus is to assist a court if there's something of substantive import which the other parties have not addressed the court on and which the amicus is able to address the court on. I've not received any heads of Mr. Motopeng. Mr. Motopeng, do I just understand your presence as to lend support to the applicant's arguments on all three issues: condonation, leave to cross appeal, and the Section 18.3 application? Or how must I understand the amicus's position?
Well, thank you, my lord. I apologize that we had a network connectivity problem.
I'm glad you could join us. Yes.
Thank you. My lord, there are about four things that we wanted to bring to the court's attention. The first part is let me just say, today is my grandmother's birthday. She is 94. She's in Soweto. Birthday I should be living, but I felt this is very important for us to address. The second issue, the first issue, that one is just the first issue is about the virtual hearing, my lord. Yes, we welcome the we are now into the fourth industrial revolution, and therefore the new innovative ways of connecting and being able for the court to be able to present is welcomed and appreciated. However, in so saying, the reasons that the state put in terms of a visual sitting were an attack to the judiciary. In so saying, may I quote, in their letter of requesting that the matter be heard via visual, they're saying, I quote, in our previous experience of a physical hearing in this matter, the applicant for leave to appeal, there was no adherence to the necessary health protocol of physical distancing, wearing of mask, sanitation by many in the court. This poses a risk to us, particularly those who are vulnerable to the complications arising from COVID-19 infection. My lord, I'm saying this because I am currently at the High Court in Victoria. To also try, I wanted to witness what they were saying. Probably maybe I missed it the last time. And the court adheres 100% fully to the COVID protocol or to the health protocol. And therefore, their statement to us was more of an attack to the judiciary, but not giving the judiciary their reasons. It would have been fair if they would have said their members are staying far or their prosecutors are far and so on. But their statement was clear that it was an attack to the judiciary, and that cannot be must not be.
Mr. Motopeng, thank you for standing up for the judiciary. I'm sure we can stand up for ourselves. I did not view it as an attack, and might I remind you of the practice directives implemented by the Office of the Chief Justice and also our Judge President. And the principle is during these times that if we can avoid risk for a party who fears a risk by way of a virtual hearing, we should do so. And we attempt to do so as long as that does not limit a party's right of access to a court. We've now seen, fortunately, that Mr. De Beer, yourself, and also the legal representatives of the minister are here, and there's no actual prejudice to any party. But I hear what you say. You take umbrage at some of the statements made in the letter. But having now at least facilitated also yourself, your presence, and so on, then it means that everyone has an opportunity to be heard.
Yes.
Thank you. Yes, you mentioned you had 4 points. The second, third, and fourth points are?
Well, I'll just quickly combine them quickly. We have always said that COVID-19 is not a disaster. However, the state has brought a disaster to its own people. We've continued also to say that the state enjoys a state of anarchy where they don't account, and there is no place where they account. And furthermore, that the state is enjoying torturing its own people. Now, why are we saying this? We are saying this because the state has just confirmed in August by the Minister of Health, who said that child illness are more dangerous, like your polio and others, are more dangerous than COVID-19. Now, but besides that, we'd like to also bring to the attention of the court, as amicus, our role is also to assist the court as amicus, to bring to the court that on the 25th, there was a matter between Olapon Renaissance Foundation and as the applicant and the respondent being the president, which said on the 25th as a matter of agent here in the High Court, case number 38800, which the matter said as an unopposed application. And in our application, we're asking all that the lockdown be declared unconstitutional.
Sorry, Mr. Motopeng, let me just understand. So there was a matter yesterday in this division by Holobon also against the same minister?
No, against the president.
Against the president. Was the minister cited?
No.
And that application was for what relief?
It was for the relief that the matter that it was a number of reliefs, but amongst them includes declaring the disaster management regulation unconstitutional, declaring the classification of the national disaster unconstitutional, nullifying the lockdown, setting up a committee, and about 22 points.
Oh yes, the relief you also mentioned in this matter when you previously referred to your other application, the committee,
yes,
etc. Yes. And what was the outcome of that application?
Well, we have not received any outcome. So as amicus, we felt that it's important to come here and be able to notify the court of another matter.
And before which judge was that matter?
Judge Kumar.
Judge Khumalo.
Yes.
And you say the matter was heard yesterday?
The matter, yes, it was tabled for yesterday and we submitted, and it was heard yesterday. But the judge requested us to go through the document, and the state did not.
I see. Yeah. I see. Thank you.
Thank you.
Thank you, Mr. Motopeng. Mr. De Beer, before I give you an opportunity to reply, let me just hear, Mr. Trengove, would you want to address anything that the amicus has raised?
No, I don't, my lord. Thank you very much.
Thank you, Mr. Trengove. Mr. De Beer?
Thank you very much, my lord. I'm not going to be much busy with a reply. The issue about the prejudice, we have in the beginning of this hearing said that we refer to our heads of argument, and obviously the court will read our papers. We have extensively addressed the issue of prejudice, how it affects me, how it affects Liberty Fighters Network, and also the public in general. We've highlighted that
I
specifically.
recall yourself, the children, your wife. There's a reference to some use of alcohol and then smoking as well, although that wasn't part of the application itself. Then there's a reference to all the tenants and landlords, and then also the 114 other taverns, pubs, and restaurants also having membership, I think, in Liberty Fighters Network, and also the lack of income. I've read that. I'll revisit that again.
Yes. I trust my Lord will. Very importantly, in what we have addressed is the issue, just to show how irrational the minister is actually continuing on with the drafting of and the promulgating of all these regulations. We have highlighted the issue of the evictions and also the issue of the rental housing problems that was now specifically addressed in the new level 2. And we have extensively said why it's totally, we basically say that it's respectively incompetent to have done what was said. That just goes on. The separation of powers have been raised a couple of times by Mr. Trengrove. We just would like to, from a perspective of the public and me specifically as a person, as a human being in this country, we have been affected tremendously by the lockdown. And unfortunately, the only way in which it seems as if our government, and I need to remind the respondent that the people are governing. The people, the government is merely the steward of the people who are governing. And unfortunately, we found it extremely difficult to have a dialogue with the government to try and address these issues. So we were forced to come to court, and we are begging the court to please assist. If the court cannot help us after it was declared as urgent in the first instance, and we are sitting as the people now. I already lost our legal team because our legal team had to withdraw because of financial constraints. So we are here continuing this fight as the people, and unfortunately we are seeing that the government is trying to portray as the possible one who's going to be prejudiced by if the court is going to implement the order of the 2nd of June. There's absolutely no prejudice suffered on the side of the respondent. They have been manipulating, also respectfully said, this whole COVID-19 process and the measures that arose from it. That we said, but it doesn't make sense that a minister can totally violate the Constitution based on the remedy or the principles contained in Section 36 of the Constitution, yet the Disaster Management Act, specifically Section 27, which deals with the powers of the minister, nowhere is there stipulated that she has got the right to change or violate human rights. That right has not been given to the minister, and she keeps on doing that. And that is the problem. We want our freedoms back. We want our liberties back. We want the correct processes to be followed. Mr. Mutupeng addressed the issue of the virtual hearing. Unfortunately, I'm not. Just the important thing that I just quickly want to add there is in fact a video of that day by the SABC, and clearly on that message, the court did ask Mr. Trengrove whether there is sufficient social distancing. Mr. Trengrove answered yes, he believes so, and afterwards he even took off his own mask. So to come back and say that their lives they fear for their lives basically by having a virtual. I think unfortunately that the legal team of the respondent have taken or have misrepresented the situation that day in court, and if need be, the court should actually have a look at that video and see whether there was actually any problems, and if need be, this court need to then take the measures of possibly reporting the legal team of the minister to the bar. But then the matter of before Mr. Khumalo, as stated by the amicus, it seems as if the respondent in that matter is the president, who is not before this court. So because of the matter that the president is not a party in our proceedings, it seems as if the directions are different between what we have followed and obviously what the amicus have actually put before the court. Yes, in respect of cost, we thank the respondent to agree that if the BioWatch principle is applicable in this matter as well, that because of the challenging of constitutional concerns by us should be followed, unless the court determines that we were frivolous or vexatious in our prosecution. That counts obviously in the case if the leave application is dismissed, together with and also the application in terms of section 18.3.
18.3.
And then just the last point. Yes, it is not correct, according to us, that if the court says that the order of the 2nd of June should become operational immediately, or at least part of it, as the court have basically dissected, if I can use that word, in the leave application, leave judgment, of identifying certain parts which were obvious to be unconstitutional, to then at least follow the same route. We would like this order to come into operation as a matter of urgency and get this over and done with. Let the government, they've got the resources. They are the ones with the legal teams. They currently have 4 advocates representing the respondent against me, who is only a layperson. So they do have the resources to draft quickly, effectively, alternative regulations in order to take the measures of COVID-19.
Yes, except Mr. De Beer, that Advocate Trengrove doesn't draft regulations.
We don't know that yet, but yes, my lord. But she does have basically an unlimited resources of professionals who have been assisting her all the time. So if the court, would the appeal be moved if the regulations do come, or the regulations are immediately invalidated? We are saying no, because of the fact that the minister or the court, the Supreme Court of Appeal, can still decide and make a ruling on the validity and the ground setting out what the procedures that were followed in that relation, because ultimately there will be repercussions for the government if it's found that they have taken irrational steps, actually grossly negligent irrational steps, which could be a possibility. Then unfortunately, this government of ours could face a tremendous amount of legal challenges against them.
Yes. You say that despite the fact that we're now in the lockdown level 2, a different chapter of the regulations, that does not mean that the question of the initial constitutional validity or irrationality falls away.
Correct, my lord. Correct.
Yes, there could be consequences. Then should the appeal court find one way or the other.
That's correct, my lord. And the executive, Mr. Trengrove, said that I am, or he made the assumption that it's not for me to tell the government, to the executive, what they should have done with the national state of disaster. The fact is that there's a responsibility of the executive to act responsibly. They must act responsibly. They must take all the facts into consideration before they make a decision. As I've addressed in the heads of argument as well, in relation to the Freedom Front Plus case, it's very strange because the Freedom Front actually asked the court for, although they were part of the support initially to declare national state of disaster, they should have logically had the information with them in order to support that they gave to the minister. And now, in that case, it seemed as if they don't have it, yet because of the fact that they are asking for that proof. So it means that that proof was never available from the word go. So at the end of the day, the minister is trying to say that she did not act irrationally. But she could only have reacted rationally if she had the information before her justifying the decision, a drastic step to take us into a national state of disaster. She could not have only relied on assumptions made by the World Health Organization. Whether we like President Donald Trump of America, yes or no, but even America have made a decision to exit the World Health Organization because of the way that the World Health Organization have attended to this COVID-19 crisis. So they have, as a sovereign state, have addressed all the relevant issues just like our government should have done. They should have taken, irrespective of what the World Health Organization, which could have, for example, be a terrorist organization or infiltrated by terrorists, they have actually put our country in harm's way. That is what she did. She should have had all the basic information before in order to address that. So, my lord, our founding affidavit, replying affidavit are very clear. We do know that the court will read through that and our heads of argument, and also through the leave application to cross appeal. And that is basically, I've addressed all the major points, and we are confiding in the wisdom of this court to make a right and just decision under the circumstances that we are facing. We are not out of the restrictions. We are saying that those restrictions should never have been there. So to make an assumption that there were or there is alleviation through level 2 at this stage cannot go. It simply cannot go. And we thank the court for the opportunity to have addressed the court via a virtual hearing. Thank you, my lord. I'm finished.
Thank you, Mr. De Beer.
Lord, may I respond to Mr. De Beer's accusation that I misled the court? It is gratuitous and irrelevant, and it is false. Various members of my team, including myself, felt uncomfortable during the previous hearing, particularly when the court was not in sitting and one mingled with colleagues and clients and public. One example I remember is Mr. De Beer's attorney, then attorney, who's a friend of mine, who came to speak to me in his normal explosive way with his mask under his chin. Now, I didn't say anything and I forgave him, but it is unsafe. And for Mr. De Beer, gratuitously, without justification and for no good reason, to make that public accusation is quite unfounded.
I've noted that, Mr. Trengrove. Thank you. Linking on to what Mr. De Beer said in conclusion regarding level 2, although the argument is, of course, regarding the regulations, etc., it is a fact that that lockdown level 2 has ameliorated some of the restrictions and interventions. To an extent, that has also impacted on the immediate urgency of otherwise dealing with the matter. Taking that into account, as well as the fact that there had been a delay in any event in launching the application for leave to cross appeal to such an extent that a condemnation application has been necessary, the urgency has to some extent diminished from what it had been when the application was initially heard, argued, and judgment then reserved. I mentioned this so that there's no expectation that if I reserve judgment, it will be again with the same shortened time period as earlier, although I will do so as soon as possible, but cannot fix a specific time otherwise. The consequence of what I've now said is that I will take everything into consideration, reread the papers, as well as the case law referred to, as well as, for example, Freedom Front, which I have in front of me as well. There are, in fact, according to SAFLI, 45 judgments in which COVID-19 has been referred to in this division alone. So the references and to what extent decisions made by the full court of this division impacts on the matters at hand will also have to be examined. I'll look at all of that and therefore cannot give a specific time. Rest assured, it'll have my attention, and as speedily as possible, I will produce a result. But thank you for your arguments. Thank you for the contributions by the amicus curiae and for the aspects referred to in the heads of argument. Judgment is then reserved.
Thank you, my lord.
As my lord pleases. Thank you.
Thank you, Mr. Speaker. We are then adjourned.